This is not for commercial or commerce. This is a learning video. I'm not an attorney, so don't take anything as such. It's just anything I say or do may be only by my opinion only. You may have to find a competent attorney for yourself. I don't never look straight forward. I always look around me, just to be able to protect myself by any means necessary. That's my inalienable rights. Let's see here. So this is going to actually be part 2, and it may be a different name. Again, I didn't really see a whole lot of this video, so we're doing this in sections. Just to kind of spread it out where it's not all at once. These videos are pretty long as it is.
Then that's what they're liable for, the terms of that Constitution, those that would be governmental. Not one of them, at least in Texas, takes that oath. I have not found one single Article 6 oath in all the requests that I've done through the years. Not
actually through the countrywide, they don't take it. Senators don't take it. Congress don't take it. Judges don't take it anywhere in the United States, or in the United States of America, or in the U.S.
Not one of your elected officials is bound to support the Constitution. And more astonishing than that tidbit of information is, we allow them to get away with it. I have begun writing pleas to the jurisdiction before a court hearing. Here are a few of them.
We all have a deep fascination with light.
Always something popping up. Pop, pop, pop.
This is one that I put in for my son. He didn't have a driver license, and they were going to put him in jail for 2 years. That was the price he had to pay, 2 years in jail for not having a driver license, which is, we don't need anyway. He had been picked up and picked up and picked up for having no driver license, and he had beat everything except this one was appealed to the county court at law. And Bill Swaim, who is the special prosecutor of the county for the Travis County, had told him he was going to get 2 years, and Swaim was going to see that he got 2 years because he had, when this one went away, he had 4 more coming up, and one way or another they were going to get him. He told him. I heard him say that to Craig. Okay, we're going to go over this because
that sounds like retaliation to me.
it's really important, and this just clarifies what I'm talking about with the oaths. Comes now, Craig Robert Pease notices this court of the following. County Court at Law, number 9, County Court at Law, Judge Williams, before assuming the duties of the office of County Court at Law Judge, was required to file the following documents in order to assume the office lawfully. Texas Constitution, Article 6, Article 16, Section 1, Texas Local Government Code 81.02. That has to do with the bond and oath. Texas Constitution, Article 6, Statement of the Officer, Texas Government Code 25006. They have to have bonds and oaths and the the constitutional statements. And I didn't even know about the Article 6 oath. You can forget, that's not even on here, but they for sure didn't have that. An officer who is required to give an official bond shall file the bond with the officer's oath of office. An officer who is required by law to give an official bond and who fails to execute the bond within the time prescribed by law may be removed from office. What it says is it has to be filed after they're elected and after January 1 of the following year and before they assume the duties of the office. They have a specific time frame. Their stuff can't be dated before January 1, although I always let the bond slide, because I'm not sure about that. January 1 is the beginning of the regular term for county precinct officers elected in the previous general election in November. Those elected officers are to qualify and assume the duty. I didn't know this was in here. Sorry, it's redundant. Duties of the office on or as soon as possible after January 1. Ms. Williams was appointed to the position of County Court at Law Judge on March 22nd, 2016. You see, she was appointed, not elected. Ms. Williams signed the required bond in the amount of $10,000 payable to the County Treasurer of Travis County on March 22nd, 2016, and signed the oath of office on the back of the bond on March 22nd, 2016. Ms. Williams, therefore, meets the statutory requirements of Texas Government Code 25006. However, a search of public records does not reflect the filing of the Texas Constitution Article 16, Section 1, Oath of Officer on Statement, or Statement of Officer of Ms. Williams for the term from March 22nd, 2016. So when she was appointed, she put those two things in, the bond and the oath, but she didn't put the statement in. And what the Constitution, Texas Constitution says is the Article 16 statement must go in first. It has to be filed before the oath. So if they don't file a statement, the oath is no good because it has to be done in that order. Public record reflects that she did file a statement and oath of office on December 20th, 2016, allegedly for the term that was expiring. She tried to correct it. These documents must be filed when she was appointed and before she assumed the duties of the office. Therefore, Ms. Williams did not sit with constitutional authority from March 22nd, 2016 to December 31st, 2016. Kim Williams did not assume the office lawfully. Now, the reason I have her twice in here is because she was involved in a court with him before, which she found him guilty. The jury found him guilty. It was appealed to the appellate court and reversed. So we had to include both her terms here. That's why she's in here twice. Ms. Williams was elected to the office of County Court of Law Judge on November 8th, 2016. Merchants Bonding Company issued a bond to Ms. Williams on November 2nd, 2016, 6 days before the election. The signature of Ms. Williams was notarized on the bond on November 28, 2016, after she was elected. The official bond must be filed with the officer's oath of office. Ms. Williams did not fill out the oath of office of county judge. Now, she did when she was appointed, but she didn't when she was elected. Although Sarah Eckert signed the bond on December 8th, 2016, showing the date the bond with no oath was approved in open commissioner's court. They can't do that.
Now I want to pause that again. Okay, so remember, she did not know about the Article 6, Title 4, USC 101 that they must sign. So she didn't bring this one up, but I guarantee that judge didn't fill that one out because none of them do. Our representative is supposed to fill that out. We literally do not have any government officials. It's what you call a correct government. They're literally corporation government and not actual government, and this is one of the ways they get around it by not taking these oaths. Oh, by the way, this Article 6 oath is supposed to be filled out with their full legal birth name. Oh, and without so help me God. Alright? Has nothing to do against God or for God. It just happens to be with that's the original text of the Constitution. Mainly probably because of the separation of church and state, so that way they couldn't play favorites.
It's got to be in its entirety. It's both constitutional and statutory. The official bond must be filed with the officer's oath of office. Ms. Williams did not fill out the oath of office of county judge, although, forget that. For the term beginning January 1st, 2017 to December 31st, 2021, Kimberly Williams did not meet the requirements of Texas Government Code 25.06. Therefore, she is not bonded. Now, one word about the bond. Once upon a time when we had officials in this country, when they were really government officials, they had to own property to get elected, and they had to pledge their property, and it had to be a freehold. They had to own it free and clear. They had to pledge their property, their freehold, to the people in the case of malfeasance. We have no bonds made out to the people in this day and age. They only make it out to the people. They take money and they make it out to the people they have to pay the money to. That's the only bonds. It's all in house there. They owe nothing to us. Nothing. Ms. Williams signed her constitutional oath of office and statement on January 1st, 2017. The statement must be filed before the oath, and Ms. Williams did not take care to make certain that the statement was filed first. Also, the oath of office was sworn and subscribed by Nancy Hohengarten, who she's another county court at law judge, who has never filed an official bond with oath of office and therefore does not qualify as one who can attest to an oath. You can't just look at these things. You got to examine them and you got to know what the rules are. And for anybody that really wants to make a study of this, there is a booklet put out by the Texas County Association of Counties. It's available online and they update it every year, every 2 years. And it tells every single piece of paper, with the exception of Article 6 U.S. Constitution oath, that an official in a county has to have. So this is all you have to do is put oath and bond Texas, and this thing will pop up. And I always keep a paper copy because I use these a lot. Ms. Williams had not met the criteria to sit as the lawful judge in Travis County and therefore has no authority to adjudicate whether or not I have a driver license. The requirements for an assistant county attorney are, off this statement, Mr. William Swain, senior special Travis County prosecutor, now and at the time he filed an information against me in 2016, filed a statement dated January 22nd, 2013, but failed to file a constitutionally prescribed oath. For the current term, which began January 1st, 2017, when David Escamilla, he's supposed to be the county attorney, was reelected in November 2016, Mr. Swain filed a statement as required, together with an appointment, but failed to file a constitutionally required oath. Mr. Swain does not meet the criteria to act as a lawful assistant county prosecutor. I have great trepidation to even appear in an alleged court of law when I have knowledge and proof that the two main players in the room did not have the competence to file the required documents that would cloak them with authority. These two, Kim Williams and William Swain, are attempting to incarcerate me for my religious beliefs, and when they are not public officers and have not filed the required documents to cloak them with authority. I have totally lost faith in the judicial system, and as a result, am in fear for my life. Magic words. So, this is her first bond, Kimberly Williams, when she was appointed. You see on this one, when she didn't know what she was doing, she actually filed the oath on the back. You'll see all of these oaths of office, and not one of those is filled out. Not one on a bond, ever, except she was appointed and didn't know any different. So she filed the oath on the back. Then her next filing was the oath of office and that she signed when she was appointed, but there's no. Oh, and here's her statement. That's her appointment one. Now she comes to the elected. No oath on the back. This is one that they bonded her before she was elected. This is her oath of office signed on January 1st, 2017. Followed by her statement backwards. The one has to be filed before the other, it's clear. And here's William Swain's oath of office. Statement. He has an oath of office. This is, I think, if I remember what I read. But this is the statement of the elected officer. And here's his second statement, because we were doing 2 terms. And here's his appointment by Escamilla. And they do have an oath on the appointment. But it's not, there's a word out of sync that doesn't qualify with the Texas Constitution at all. Therefore, there is no oath. It has to be word for word as it's put out in the Texas Constitution. These people take great care not to file the required oaths. Do you know what happened to Craig? When he put that in? He was discharged. They threw him from the courtroom. He said, I am removing you from the court. That's not a dismissal. I am removing you from the court, he said. And they don't want him back. And a couple of weeks later, when I looked on the charges, they had all the charges that were discharged. That's almost the same as it being extinguished, because they'll dismiss, but the charges will stay there. He has no charges because they're always money charges. You think you're being charged with no driver license? I promise you, there's a ledger. That's what you're being charged with. You get to pay it. I repeat, not one.
So you guys fully understand what that was talking about. People says, well, I don't see, any type of court documents, under this and this and this, right? That's because they do that. When people talk about private courts and all that, they still have the court, but it cannot be on record because it cannot be used against the courts that you was correct, not the courts. They cannot have that on record. And that's the reason why it wasn't dismissed, because if it was dismissed, it would be on record in the courts. And anybody can just look it up and read the documents and all that. But in this case here, nobody can look it up because it was never recorded. It just kind of disappears. The paperwork she's shown. Well, what about the paperwork she's shown? When you do these paperwork, y'all, you always make a good couple of copies for yourself to keep, because anything can arise in the same courts. They're crooked. If they're going to try to be snakes and slither their way through, they're going to do it. So you always keep one on record in a filing cabinet somewhere for the rest of your life.
Of your elected officials is bound to support the Constitution. And more astonishing, we allow them to get away with that. Oh, the police of the jurisdiction. I've not yet found, I wanted to say, show one closer to home, because this is Dr. McCann's plea to the jurisdiction in a lower court. And this is kind of the one I'm doing now. Michael McCann, a man, presents his plea to the jurisdiction in response to the citation issued to him on February 6, 2019, and gives notice of the following. Michael McCann has signed no contract to be bound by the Texas Transportation Code or the Texas Penal Code. Why does he have no contract? No driver license. He never signed the contract. Michael McCann is not a man who can be presumed to be bound by the Texas Transportation Code or Texas Penal Code. Michael McCann demands strict proof that this court has jurisdiction over a man who is not contracted to be bound by the Texas Transportation Code or Penal Code. Further, the justice presiding over this court has no authority to meet punishment to Michael McCann, a man. Sherry Kirsch, the justice who allegedly presides over this court, has failed to meet the criteria to assume the duties of the office of Justice of Peace. Ms. Kirsch was elected to the office on November 6, 2018, in order to secure the blessings of the office and to sit in a de jure lawful capacity. Ms. Kirsch was required to fill out and file in public records certain oaths and bonds in order to legally and lawfully perform the duties of the office. The Texas Constitution states that Texas is a free and independent state, subject only to the Constitution of the United States. Texas Constitution, Article 1, Section 1. The Constitution of the United States of America, Article 6, Clause 3 states, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. The oath enumerated in the U.S. Constitution can now be found in 5 U.S.C. 1331. Ms. Keith has failed to take said oath. The Texas Constitution at Article 16 mandates that blah, blah, we've been through that. Ms. Kirsch failed to file the Texas Constitution Article 16C Statement of Officer. The statement referenced above must be filed before the Texas Constitutional Oath of Office can be filed. Ms. Kirsch failed to file the required statement. Therefore, the oath of office which she filed is not relevant, as she failed to follow instructions. A public official, in order to be cloaked with the requirements of office, must take several oaths and blah, blah, blah. We've been through that. She failed to file them. Ms. Kirsch has no jurisdiction to sit in the position she appears to hold. As one of the people, Michael McCann gives Ms. Kirsch notice that because she was not competent to fill out and file the necessary documents which would allow her to sit as a justice of the peace, that she shall immediately remove herself from office. The people of the Republic of the United States of America and Texas will no longer tolerate usurpation of officers subject to election. And we filed one of these for Tom, and Tom, what happened with yours?
What was that?
We filed one of these plea to the, wasn't it with this same judge we filed?
Same judge,
And-
and everything was dismissed because I did what you gave me.
Yeah.
I went ahead, took your paperwork, and looked up her oath of office, which was missing. And of course, they would never give you any indication they were paying any attention. But all of a sudden, I get this letter back. It's been dismissed.
Yeah, we have to shine the lights on these rats. I have not yet found a single U.S. constitutional Article 6 oath for anyone in Texas. Everything we allow these government officials to do to us is legal and lawful. You understand that, don't you? Whatever they do to us is legal and lawful. Why? We volunteer for all the abuse and therefore cannot complain. And if we can't complain that we didn't get full disclosure or any of those other things, what do they say? Ignorance of the law is no excuse. Our consent is our contract with the usurpers. We allow them to govern us in any manner they see fit to impose. Where are we at this stage of the game in history? We are in bondage. We look no further than the Lieber Code. Lincoln's General Order 100. Has everybody read this? This is almost as important as the Declaration of Independence. Lincoln said in 1863, April 1863, the reason we're filming is this. I want you to watch this over and over because I want you to grasp every concept in here, and you're not going to be able to do it in one speech. You're going to have to look at this stuff until you understand it and it becomes part of your bone marrow.
Dispense supplements in office or virtually on one platform.
A place, district, or country occupied by an enemy. And who's the enemy? We are. In consequence of the occupation under the martial law of the invading or occupation army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not, martial law is in immediate and direct effect in consequence.
We're going to pause that. Listen to that one part right there, y'all. Who's the enemy? We, the people. You wonder why that constitutionalist is on a terrorist watch list? Because under martial law, we, the people, are the enemies. Period.
Of occupation or conquest. All those years you were fighting that flag with the gold fringe on it, what was it a sign of?
Slavery.
Military occupation, military courts. The martial law does not cease during the hostile occupation except by special proclamation either ordered by the commander-in-chief or by special mention in the Treaty of Peace. I wrote a letter that was supposed to have gotten to President Trump, and I asked him to do this very thing. All I can think is it didn't get to him. Concluding the war when the occupation of a place or territory continues beyond the conclusion of peace is one of the conditions of the same. Well, we haven't had that, have we? You see, this occupation, except...
I'm not being mean. But for argument's sake, what if it did get to him? That means he didn't sign it, and he kept everything the same. Wonder that, y'all. I mean, it's highly possible he didn't get it. But just the same, if he did get it, and he didn't sign it, he was no better than any other president. He was just as bad as Lincoln because he kept it.
Here's the Treaty of Peace again. Occupation, occupation, occupation. Okay? Then, if you don't read, this is for us. This is the handbook that they use to oppress us. So, if that's not enough for you, there's a book written by William Whiting. He was the Solicitor General. This is War Powers Under the Constitution of the United States. And it's written by William Whiting, who was the Solicitor General under Lincoln. It's a huge, sloggy tome, let me tell you. My son has read it 6 times. I just took his word for what he read. Except now I have it chapter by chapter. What William Whiting says about the law administered by military governments, we're talking our courts now, we're talking our laws. As the powers of a de facto government, see, they can sit de facto. That is a military government over us is de facto, and they can sit de facto. Everybody know de facto? They are not lawful. Belong to the conqueror by the laws of war. He may suspend, modify, or abrogate all municipal laws of those whom he has conquered. He may and how did they conquer us? With the order, but how else? With the dollar. And it's them that conquered us, the bankers. He may disregard their former civil rights and remedies. He may introduce and enforce a new code of laws, military and municipal, and may carry them into effect by new military tribunals, having abolished all courts and offices held under the authority of his enemy. We have no legitimate courts, especially civil courts, well, criminal too, in this land. None. They are all military in nature. It has been held by the Supreme Court, this is the Solicitor General saying this, it has been held by the Supreme Court that the laws, whether in writing or evidenced by the usage and customs of the conquered or ceded country, continue in force till altered by the new sovereign. Who will that new sovereign be?
Military.
The people. We will be, the people as one unit will be the new sovereign. There is only one sovereign, and he doesn't live here. We are subject to a sovereign. But when you're talking about political sovereignty, you're talking about the people as a body of one. There is nothing more powerful. Nothing. All these propositions follow from the fact that the power of a public enemy to make or administer law is terminated by the conquest of their territory by different lawmaking and law administering power vis-a-vis that of the conqueror.
Okay, we're going to stop it right there because this video is getting long. Alright, this will be the People News. Bye, y'all.